What is criminally negligent homicide in New York? In New York, you can face a felony homicide charge even if you never intended to hurt anyone. And understanding why requires a close look at the law. Under New York Penal Law Section 125.10, criminally negligent homicide occurs when a person causes another's death by failing to perceive a substantial and unjustifiable risk that their conduct would result in death. This charge is classified as a Class E felony, carrying a maximum prison sentence of 4 years, along with possible probation of 3 to 5 years, and fines of up to $5,000. The mental state behind this charge is defined by New York Penal Law Section 15.05(4), which holds that criminal negligence requires a gross deviation from the standard of care a reasonable person would observe. It is not enough to simply make a mistake or exercise poor judgment. The conduct must deviate so dramatically from ordinary care that it crosses the threshold into criminal liability. The New York Court of Appeals confirmed this standard in People v. Haney, emphasizing that criminal negligence demands far more than the simple carelessness that might support a civil lawsuit. To secure a conviction, the prosecution must prove 3 elements beyond a reasonable doubt: that the defendant failed to perceive the risk, that their conduct was the proximate cause of the death, and that a human being actually died. The key distinction between criminally negligent homicide and manslaughter in the second degree comes down entirely to the defendant's mental state at the time of the incident. Manslaughter in the second degree under Section 125.15 requires recklessness, meaning the defendant was actually aware of the risk and consciously chose to disregard it. Criminally negligent homicide, by contrast, applies when the defendant failed to perceive the risk at all, a distinction that separates a Class E felony from the more serious Class 100 felony of manslaughter. New York also recognizes aggravated criminally negligent homicide under Section 125.11 when the victim is an on-duty police officer or peace officer whose status the defendant knew or reasonably should have known, elevating the charge to a Class 100 violent felony. An attorney defending against these charges may argue that the conduct did not rise to the level of criminal negligence, that causation cannot be established, or that the mental state attributed by the prosecution is overstated. A skilled lawyer who understands the precise line between negligence and recklessness under New York law can make a significant difference in how these charges are evaluated and resolved. Call the law offices of Jason Bassett, PC at 631-259-6060, located at 320 Carlton Avenue #4200, Central Islip, New York 11722, to schedule your free consultation today.